Jails, prisons, bonds, research explaining how living souls are made prisoners for the making of billions of dollars for the slave-making governments and their banking henchmen through incarcerations. I do not know for sure who wrote this, but it looks to be right on the money in most cases, and I recommend some Texans trapped in these dungeons on the land of Texas try this. Greg is investigating more into the criminal jail prosecution aspects. The results are incredible. His straw man is currently on probation from activities that were the result of Cliff prosecution of 17 to 18 people who were attempting to help patriots to buy Cadillacs. He was put in jail for a year, then a halfway house. He's been researching Admiralty. When he was ready to leave the halfway house, he was caught on the computer creating a bill of exchange, and the guards and matrons thought it was criminal activity, so they jerked him back into jail for violating his probation for putting a blank bill of exchange. Jack had advised him that he had to quit fighting these people or he'd be in dishonor under Admiralty, and he had to keep raising questions rather than fighting and denying the charges. He was only in jail about 4 or 5 days, and when they tried to interrogate him to get him ready for his hearing where the judge would eventually put him back into prison, he started using the correct tactic of accepting and asking questions. He got the prosecutor assistant to throw up her hands and scream he was too smart for her to just get out. He's been in a halfway house since May. The last time he had a probation hearing with his officer in Cliff, he had gone to the meeting personally. Before he went, he had written a letter to her, the judge, the prosecutor, and others, and said that he requested that they deliver to him the bonds from CUSIP Committee on Uniform Securities Identification Procedures. CUSIP, the committee that assigns the numbers to securities for identification, usually bonds. Glossary, CUSIP, Committee on Uniform Securities Identification Procedures. CUSIP, the committee that assigns which were being used to underwrite his time in prison and his time on probation. He wanted them to deliver the bonds being held by CUSIP and other government agencies so he could accept them for settlement and closure. When he went to his probation officer meeting, he was disappointed because his probation officer wasn't there to meet with him. He filled out a form and left. It seems that no one wants to talk with him or meet with him now that he's asked for the CUSIP bonds so he can settle and close the bonds. CUSIP is an acronym. GXXX is telling us that all criminal prosecution is for the purpose for raising revenue for the United States of America, and he'll tell us who that is. Now you'll have a better understanding of why people are in jail, why they are in prison, why they are on probation, and why they are charged with everything from jaywalking on up through murder. 1. Jack further heard from others researching, and GXXX is also saying that every American soldier who dies in Afghanistan and Iraq probably carries a $10 million life insurance on him carried by our government. After all, every soldier, Marine, or Air Force person is an asset to the United States of America. They have a huge investment in that particular soldier and his activity, and it can explain why it is that the U.S. is not so anxious to withdraw its troops from that area. It's a money-making activity, and they don't want to talk about the fact that they are making money on death and that they are making money the incarceration and imprisonment on otherwise good-hearted people. GXXX, the key to finding out what you want on the internet knows how to put it into the computer. If you put the right information in there, you get the right answer. He's been finding out who the investor is, the 144 holders. They have a rule called the 144 holder. The rule is that they can't sell private investment securities that are not registered. The rule prohibits them from selling the prison bonds. They have to wait 6 months before they can sell a certain quantity of private securities without being registered, selling them as private securities. Basically, there are 8 people on the board of directors of CCA, Corrections Corporation of America. www.correctionscorp.com. Joseph E. Russell, the top holder, and John M. Ferguson. Russell owns 64,000 shares of CCA stock, which is worth about $70 million. Ferguson owns 34,000 shares valued at about $37 million. Fidelity Management and Research is the top stockholder, the top investment firm that is selling the bonds as investment securities. They pool them and sell them as mortgage-backed securities. They also, when they pool them, they sell them as mutual funds on the stock market. By pooling you mean the securities on the inmates. What they are doing is they are actually taking the mortgage-backed securities, which are really bid bonds, performance bonds and payment bonds. They pool these bonds, and when they pool them together they call them mortgage-backed securities. They take these to TBA, which is the Bond Market Association. It's an actual market for bonds. Anytime a bond is issued, there has to be an underwriter. The bonds have to be underwritten. Bonds that are issued have to be indemnified, so there has to be surety, spelling, to indemnify the bonds. The brokerage houses and the insurance companies indemnify the bonds. They're called surety companies. After the surety companies indemnify the bonds which are underwriting them, they do this through an investment banker, or the banks themselves do this. They job it out to them. They buy up all these shares and turn around and sell them as investment securities. The shares represent the stock, which represents the account of CCA. All of this has been funneled through CCA, the Corrections Corporation of America. What they are doing is selling stock in the prison system. By selling the prisoners' accounts as securities through the securities exchange, they are making huge amounts of money off it. They privatize the prisoners' accounts and bring all these investors in, and what they are doing is underwriting all these prisoners' accounts bonds. This is after the surety company guarantees the bonds. Then they are underwritten through an investment bank or banker. Then they are put out on the market and resold to the public. In other words, the banks are buying up all the shares and then they resell them as investment securities to the public. The public then buys them as mutual funds, or they can buy them as debt instruments, equity instruments. What they are really doing is they are buying up debt instrument. They are using the fiscal accounting cycle of accrual, and they sell the prisoner's capital and interest, as it is called in accrual accounting. They resell these to the public because the prisoner did not do full settlement and closure on the account. They sell the prisoner accounts as a commercial dishonor and sell it to the public as a commercial dishonor. When you go in the courts, they always say they are operating under a statute jurisdiction. The Black's Law Dictionary 4th edition says a statute is a bond or obligation of record. That's what all the criminal statutes are. Bonds are obligation of record. Go in and read the definition of a recognizance bond and you find that it is a bond or obligation of record. They are selling bonds. They are charging prisoners under a bond. The prisoner signs the bond and the bond becomes the agreement for the payback. This is done when a prisoner signs the final court papers at a sentencing hearing. Jack, how many of us remember when our government attempted to finance from the private sector the Second World War? Weren't they selling war bonds? They were soaking up the people's equity in terms of buying bonds, transferring your funds to the government. The government, by purchasing those bonds, was promising to pay you back your investment at some time in the future with interest. At that time, what they were collecting from the people was their so-called cash equity. What Gene's saying now is that people have gotten too poor, too stingy and too smart to buy bonds to finance the government. How long has it been since you heard the post office or anyone trying to get you down to buy U.S. savings bonds? So what they are doing now, instead of getting us to voluntarily give our cash equity to the government for a promise to be paid back in the future, they are securing from us some violation of a statute by which the law ascribes from us a penalty, i.e., the payment of a sum of money due Instead of collecting the cash from us, they put us through a criminal procedure where we dishonor the system, and what Gene said is what is happening is they are selling our capital and our interest. In other words, they are selling the liability you had in whatever charge has been brought against your straw man. They are taking that capital and interest that you should pay and are grabbing that from us and selling it on the open market to bankers and investors to transfer their funds to government, which is covered by the bond of the violation of your straw man of that statute. In order to secure the bond, the living soul is placed in prison as the surety to back the bond, which is financed on the investment of the public marketplace in terms of the sales of stocks and bonds. The public doesn't directly bid on the prisoner's debt. Your debt is assumed by the bankers. The bankers issue secondary paper that allows me to invest in what they are holding as the holder in due course of the claim against your straw man. The reason they are doing this is because you dishonored the post-settlement procedures for settlement and closure of the account. The prisoner should have come in and accepted and used his exemption. Since the prisoner dishonored the post-settlement proceedings, then the prisoner is in dishonor, and the issuance of the bonds by the financing system was done in order to pass the punishment on to him because of his inability to fulfill his post-settlement objectives. If you get into dishonor by non-acceptance, what they are trying to do is get an acceptor, which is the same thing as a banker. They need someone to pay off the obligation, and if you get into dishonor, they sell your dishonor and put you into prison as the collateral, and they sell the bond. The bond is issued and they get a surety to underwrite the bid bond with the performance bond, and then they get an underwriter to underwrite the performance and payment bonds. What the performance bond is it guarantees the bid contract or the bid bond. What the bid bond is guarantee the payment of the performance bond. This is done through a surety company. Then they get an underwriter or an investment banker to underwrite it. After it's underwritten, they sell it to the public as investment securities, debt instruments, or mutual-backed securities. It's all done through bonds, bonding. That's what all these municipal bonds are. What they doing is following everything through the prison system. The prison system is being privatized. Through privatization, private enterprise can fund the prison system cheaper than the government can. They're subsidizing everything through privatization. ALEC does this. The American Legislative Exchange Council promotes privatization through foundations like the Reason Foundation, owned by David Knott. They get the foundations to promote this and get investors to come in. Cornell was merged with Trinity Venture Company, which is an investment company. What they did was changing their name to read Trinity Venture, and then merged with S.B. Warburg. Warburg was out of Germany or France and partnered with Rothschild. S.B. Warburg is in Chicago, Illinois, and they merged with BIF in Switzerland, which is a settlement and closure bank, and the biggest bank in the world for settlements. They are connected to Cornell Company, which is owned by David Cornell. Everyone is Titan. Paine-Webber Group is the United States of America, and all the big international corporations are the stockholders and own all the stock in CCA. Everyone is using our exemptions on the private side. They filed a 1096 tax return and show it as a prepaid account, as prepaid interest, and they returned it back to the prisoner. They took the prisoner's deduction for the exemption and they deduct the tax, and the IRS bills the prisoner for the tax. So the corporations are stealing your exemption, which is your intellectual property. What's wrong with this? They are not telling us what they are doing. It's all commercial. When you go into the courtroom, everything is commercial. VXXXXX in her seminar says the facts don't matter. The facts are on the moon. What matters is honor and dishonor. The courts have to dishonor the potential prisoner or get that person to argue, or get that person's attorney to argue. Just like Martha Stewart arguing. You're in dishonor and you'll end up in jail. The attorneys are actors to make us think the whole process is a factual issue. They get us into the guilty, not guilty mode, and they get into all the cloak and dagger or what evidence to present. It's a dog and pony show to cover up that they are after the debt money. All corporations work on a fiscal accounting year, which means that they spend debt. They can't get rid of the debt and balance the books unless they run it through our accounts. On the private side, we the people run on a calendar year and the corporations run on the fiscal year. They can only balance their books as to run it through our accounts using our exemptions. Then they can do their reverse bookkeeping entry and go to post-settlement enclosure. They can't do that until the prisoners do the acceptance. If they do it, that what they are looking for in the courtroom under 3 to 410 is the acceptor. That means we are assuming the liability for the debt as the principal. A lot of times with debt, the principal is always the primary liabilin. In the commercial setting, he has to assume the liability and then you get your remedy. Otherwise you don't get a remedy. They sell your account to some corporation while you're sitting in prison. How many times has government ever had a case against anyone? The attorneys have to attempt to get you to go right into argument and trial and go into dishonor. Alan was given documents from Redwood Trust on a mortgage foreclosure. She did a conditional acceptance and she did a heck of a job. She stopped them cold and they took the property off the market. At the end she said if they didn't answer her within 14 days she was going to resort to notarial protest and get remedy for dishonor. She went into the fact that their charter doesn't allow them to loan credit. She wanted to know the name of the company who was the source of the credit. She wanted the name of the account number. She wanted certified copies of the font and back of the promissory note. She was trying to get them to divulge that it was her secured party creditor that was the source of everything they were doing. She was forcing them to admit that it was her promissory note that was the basis of the credit instrument that they loaned and that they had already sold the note to someone else and they didn't have it in their possession. What they do is they sell the notes just as they do when you go into prison. They endorse the note and they no longer the holder of the note. The mortgage company wasn't involved in this process. The attorneys are doing all this. What they are doing is coming to the private side to get the debt without any permission from the mortgage company. In this case, they quoted from the UCC, and it's from Lex Mercatoria, the law of the merchant. If you read John Hall's book, it talks about letter rogatory indictments, where you are indicted and brought into the court under a warrant. What the warrant is a demand for payment of debt. What they did under Admiralty in the courtroom is they are demanding payment. You sign a bond to be released until the civil complaint is prosecuted, and then they release you under the bond until civil bond is prosecuted. If you didn't pay the debt, they put you in prison until the debt is paid. They use the same terms in this practice book from 1700. This is an actual practice book. It was written by courts practice who worked in the Court of Arches for the Crown as a registrant. This is a private book, not meant for public viewing. It laws out the whole practice of admiralty during the American Revolution. Hall translated this and put it in district court in Maryland in 1809. This was written in 1692. It's an actual practice. Benedict is not a practice, it gives information about what admiralty is. Admiralty is all debt and it's all civil. It becomes criminal when the prisoner gets a contempt charge when he refuses to pay. They can keep you in jail until you pay the debt. The initial get out of jail bond releases you until you've successfully paid the debt. This book goes into the history and practice of admiralty. It tells how to set the bond and do court room procedure. The laws haven't changed, the circumstances of the government have changed, so admiralty can be applied instead of constitutional law. Warden comes from admiralty, warden of the sea. The warden is the warehouse man who is warehousing all the goods. He's the bailee. The commitment order is your bailment, your contract for the commitment of the goods. Then they put the goods in a warehouse and store them there. Prisoners stored in prisons, just like the people stored in the pods in the movie The Matrix. Section 3 to 410. Acceptance varying draft. A. If the terms of a draft's acceptance vary from the terms of the draft as presented, the holder may refuse the acceptance and treat the draft as dishonored. In that case, the draftee may cancel the acceptance. B. The terms of a draft are not varied by an acceptance to pay at a particular bank or place in the United States, unless the acceptance states that the draft is to be paid only at that bank or place. C. If the holder assents to an acceptance varying the terms of a draft, the obligation of each drawer and endorser that does not expressly assent to the acceptance is discharged. 1. Acceptor means a drawee who has accepted a draft. 2. Drawee means a person ordered in a draft to make payment. 3. Drawer means a person who signs or is identified in a draft as a person ordering payment. 4. Reserve. 5. Maker means a person who signs or is identified in a note as a person undertaking to pay. A. Acceptance means the drawee's signed agreement to pay a draft as presented. It must be written on the draft and may consist of the drawee's signature alone. Acceptance may be made at any time and becomes effective when notification pursuant to instructions is given or the accepted draft is delivered for the purpose of giving rights on the acceptance to any person. B. A draft may be accepted although it has not been signed by the drawer, is otherwise incomplete, is overdue, or has been dishonored. C. If a draft is payable at a fixed period after sight and the acceptor fails to date the acceptance, the holder may complete the acceptance by supplying a date in good faith. A. Except as provided in subsections C and D. Negotiable instrument means an unconditional promise or order to pay a fixed amount of money, with or without interest or other charges described in the promise or order, if it 1. Is payable to bearer or to order at the time it is issued or first comes into possession of a holder, 2. Is payable on demand or at a definite time, and 3. Does not state any other undertaking or instruction by the person promising or ordering payment to do any act in addition to the payment of money, but the promise or order may contain an undertaking or power to give, maintain, or protect collateral to secure payment, an authorization or power to the holder to confess judgment or realize on or dispose of collateral, or a waiver of the benefit of any law intended for the advantage or protection of an obliger. B. Instrument means a negotiable instrument. C. In order that meets all of the requirements of subsection A except paragraph 1, and otherwise falls within the definition of check. In subsection F is a negotiable instrument and a check. D. A promise or order other than a check is not an instrument if, at the time it is issued or first comes into possession of a holder, it contains a conspicuous statement, however expressed to the effect that the promise or order is not negotiable or is not an instrument governed by this article. An instrument is a note if it is a promise, and is a draft if it is an order. If an instrument falls within the definition of both note and draft, a person entitled to enforce the instrument may treat it as either owners of the prison system in America profiteering off the prisoners' prime stockholders in correction, Corp of America, funding streams exposed corporate public-private scheme exploiting, criminalizing vulnerable people. Research and excerpts from Letters from Jail from Lynn Schmaltz had many opportunities to educate women on the monetary system of jail. The moment an order is written, whether it's a warrant or a traffic ticket or whatever, the money machine is activated. Every prisoner has a monetary value to our government, whether it's local, county, state, or federal. Bonds are written based on the person's name and social security number and are sold through a brokerage firm such as Ag Edwards or Merrill Lynch, who has the contract to sell all the prison bonds for the city, county, state or federal prisons. Over 50% of the money market bonds right now are purchased in Japan or China. I've been told by researchers that Walmart and used to be Kmart also purchase these bonds, Walmart mostly doing so by emptying out bank accounts at night. Both companies are fronts for enormous money machines. The way the bond works is that a monetary value is placed on the alleged crime and then factored the way banks factor their money. In other words, if a person is convicted of a felony, that value would be $4 million. The county, city, state then multiplies it by 10, so the bond that goes out for sale with the prisoner's name and social security number is a short-term promissory note. It's offered at $40 million. Perhaps an investor will offer 40% of the $40 million, or $16 million. Once this promissory note of the face value of $40 million reaches the banks, it is then multiplied again by 200 to 300% and sold as bank securities. For those of you who wonder why the U.S. has more people in prison per capita than any other nation on earth, you'll begin to understand how we can have a weakening economy and still fund wars overseas. It's all based on prisoners, in other words, prison for profit. Knowing all this and knowing that a prisoner can have a net worth of say $10,000 per day in the money markets helped me explain to many bewildered women why they were in jail. We were only merchandise in a warehouse. The storage was pretty cheap, one woman while in jail researched. The cost of feeding prisoners per day, which ranged from 74 cents to $2.72 per prisoner per day. Correction Corp of America, headquartered in Nashville, Tennessee, owns all private prison systems in America and are selling the commercial paper. How it works: a bid bond is done on Form 24, which comes out of the GSA Office, General Services Administration, which is out of GAO, General Accounting Office, which is under the Controller General. This Blake bond bid bond is promulgated at the time the Social Security card is issued. When you are arrested, the bond is filled out and they issue a performance bond, which is done from Form 25, and then they do a payment bond, which is a Form 25A. The bonds are being underwritten by the banks. This is where the Paine-Webber Group comes in. The plaintiff in all criminal tax cases in the USA is the Paine-Webber Group as the United States of America. The Paine-Webber Group is a group of international businesses. The Paine-Webber Group is providing the securities for the prisons and is selling the bonds, and the banks, the ABA, American Banking Association, like Lehman Brothers in New York City, are the underwriters on the bonds. The banks, the underwriters, is where the money is originally coming from. A 6-digit tracking number is issued for the certificate of stocks in the Commodity and Security Exchange in the USA by CUSIP. See www.cusip.com and www.cjts.com. The law enforcement tracking software, and a 9-digit number called ordinance number is issued for the certificate of stocks. Going internationally to Anna Lynn's note, see link for Anna, which is in Brussels, Belgium at www.cusip.com. These securities are sold through the Commodity and Security Exchange. The bottom line is they are selling stocks in the prison system. The jails are referred to as warehouses and the prisoners are called goods. Oops, Lynn had it wrong, she told the ladies in Bernalillo County Metropolitan Detention Center that we were in the warehouse and we were the merchandise, which explained the many flimsy reasons many of the ladies were in the prison. It was just business and just revenue. They are selling the goods or the account as chattel, and as commercial paper on the stock exchange. Reminds one of the days when slaves were bought and sold on the auction block. The Paine-Webber Group is the prime stockholder in this CCA, Correction Corp of America. Lynn's note, the transport company who transported her to Colorado in a van with 16 other prisoners being transported about had the words in quote, Transport Corporation of America, Nashville, Tennessee, and Quat transport rides are also called diesel therapy by those who know about them. However, 20 of the largest companies such as Walmart, Exxon, General Motors, Ford Motors, Chevy, Texaco, Citicorp, IBM, EXPHILIP, Hewlett-Packard, Verizon, the United Postal Service, UPS, and etc. are also involved, as well as other stock-holding corporations. There are 16 pages of the names of corporations that hold these stocks, amounting to billions of dollars. Of course, the monies generated is all off budget with no accounting to the people, even though the Correction Corp of America through the Paine-Webber Group is acting in the capacity of the United States of America. American Legislative Exchange Council promotes privatization of the prison system. Paul Weybrook may be misspelled, runs what is called the Free Congress Foundation, which owns the American Legislative Exchange Council. The Reason Foundation and the Cornell Company are involved as well. The following are notes I wrote after Paul and I were released from Colorado on August 20, 2004. Right now there are many forms of jail in the U.S. Actual jail, CCP, ankle bracelet, transport jail, probation, parole, they all generate income. Paul and I were released on Friday on personal recognizance and allowed to go to New Mexico. We have a hearing in CO on September 13, 04. We got home Sat night and have been doing catch-up here at home. Today, I'll write an update on Monday or Tuesday. I will especially have some words about the very heinous prison transport system in our country. For now, suffice it to say that it took 20 hours in a prison van with 16 prisoners to get from Albuquerque to Hot Sulphur Springs, normally 8 or 9 hour trip. All of us rode in handcuffs and shackles the entire trip. There were 3 stops for McDonald's food. No one but the officers got off the van unless they were being dropped off. No exercise at any point. No movement allowed but to use the porta-potty on board. Cattle being transported across country are generally treated better. I talked with a man who'd been on transport from California to Colorado since July 8, 04. My transport date was August 11, 04. Someone in the Midwest told me he knew of a prisoner being transported for 6 months and occasionally dropped off in a county jail somewhere to await a different transport van. It's my understanding that once you're a prisoner in the system, the county agency holding you is floating bond for $10,000 per day with your name and your barcode, Society, Sec, Hash, and these bonds are bundled periodically and sold through Merrill Lynch, Ag Edwards, etc. for each state prison for profit. It's not just bologna and white bread. More later, and thanks for keeping up your daily news. Paul was released from CCP ankle bracelet in Albuquerque and allowed to drive up to Hot Sulphur, where he spent another 3 days in jail. My time over the summer has been 5 days in May, 18 days in June to July, 15 days in August, and on house arrest bond from May 24 to June 25, and ankle bracelet from mid-July to August 5, 04. Thankfully, Paul, with all his transplant medications, diabetes medications, was in from May 19 to 24, 04. The rest of the time, he was on bond or ankle bracelet house arrest. I doubt he'd have survived a prolonged transport situation. The alleged crime, NQuat, influencing a public office, NQuat, and NQuat, filing a false document, NQuat. This is what they called our UCC-1 financing statement sent when we informed public officials there would be a fee for using our copyrighted property, Paul Schmaltz and Patricia Schmaltz, which they did anyway. And, of course, there were no repercussions for those officials when they held a fraudulent, unpublished sale, our home business on the courthouse steps, etc. As you well know, there is no remedy in the courts of any kind. They completely ignored our sovereign status with little shell pambina and apostille with a sovereignty filed by Cancellatura. I just found the Notes on Jack Smith and Gene Keating's research on prisoner bonds, not the kind you bail out with. www.cjts.com is the criminal justice tracking system software which shows the software that Metro Police Departments use. Go to the user manual and it takes to 2% appearance bond fees. Then, go to special operating software for courtrooms and it shows you how the 2% appearance bond fees are tied to the defendant's account. Go to the bottom in the original user's manual and it says NQuat Fine Accounting, NQuat. Further up the page is Assessments. It shows how it's all tracked from beginning to end. FONTDIV. A caller wrote to a court once and NQuat send me a complete accounting of my case. NQuat. It came back showing a $90,000 active security and they said, NQuat, your paperwork has been forwarded to the Department of Justice. NQuat. The caller wrote a week later and said, NQuat, send me a final payoff amount for all my money. What would there be after 18 years without any fees, fines, and interest? NQuat. They said, NQuat, we sent all your stuff to the Department of Justice. Go to that site and you'll see all there is to see about a public witness. The caller downloaded it. Roger Elvick had written something about stock exchange transactions. Once you get the bond, your creditor, in fact, Alan, comes on the phone call with Jack Smith, who had studied Roger Elvick's stuff intensely. He understands marketing accounts in the courts. Roger had said, NQuat, we have to find a way to track the account. NQuat. The caller on Jack's program grabbed the phone book and just randomly picked a brokerage company. AG Edwards. He called up to talk to a broker. Caller says he's trying to figure something out. If there was someone trading bonds in the bond market in the caller's name without his permission, could he track the account? AG Edwards' broker says they would have to have a social security number or a driver's license number. Caller says he knows someone who is trading in Roger Elvick's name. Broker asked if it was a friend, a family member, or a corporation. Caller said to the broker it was a corporation. Broker then said every bond has a CUSIP #Committee on Uniform Securities Identification Process Number. You can go to www.cusip.com. There are two main outlets, Chicago and New York. You'd have to find out who their transfer agents are and then you could track the trade. You can even find out if funds are being embezzled off the account. When the cop gives you a ticket and you go into court, the judge is using this as a credit item to trade in the markets and he's doing calls. What if someone went in and caught them short on the margin call? The broker at AG Edwards knew what the caller was talking about. He said, NQuat, if you want to follow this up anymore, you'll have to go to the Securities Exchange Division in your state. So, the next thing the caller did was check the Department of Financial Institution of his state on the web and looked up Securities Exchange Division. The advisory committee showed AG Edwards was the transfer agent for the state, making all the bond trades. The cop does all the paperwork in the car. He is creating the assessment and the paperwork in his car when he makes out the ticket by using name, social security number, and driver's license number. They assume you voluntarily gave it to the cop and make the trade. Every cop is a private business contractor working for the corporation. If this is true, then you can follow up on every trade made in your name on your exemption. Find the bond written on your birth certificate. Use that and access your exemption through the stock market that way. Roger Elvick knew this. The transfer and transfer agent and the number with social security number and every case number will be listed. Every traffic ticket will be listed. Broker says if Ameritrade had a trade he could track it, but he can't track AG Edwards and others. It's going to take someone higher up. The brokers are enslaved by their industry. When you have a job, your company is using your social security number. They'll keep taking your exemption even if you leave that company. AG Edwards sells the prisoner traffic bonds for several states. How does this correlate with Admiralty? Jack Smith says that in Admiralty the vessels are carrying commodities and goods, so they carry invoices, packing slips and bills of lading, warrants and securities back up the goods, like goods that float on the water. Gene Keating says that Title 46 is the shipping code in Admiralty. Secretary of Transportation is the receiver of the bankruptcy of the United States. Section 1247, Title 46, he's the receiver and trustee. He's talking about the Carriage of Goods Act, which is Title 46 in the appendix. Bills of lading are all documents of title. Warrants and documents are all under the UCC and deal with documents of title. Title 46. Sections 181 to 189. Admiralty is very complex. Even judges are taught on a need-to-know basis. Appellate judges often don't know all this. This all leads to different aspects of Admiralty, maritime law, both inside and outside the courtroom. The Carriage of Goods Act, Title 46, is all governed by the Secretary of Transportation. The Coast Guard, Secretary of Commerce and the Treasury are all under Secretary of Transportation, and it's all in commerce. The Secretary of Transportation is the head of the Maritime Commission. All vessels are registered under Title 46. Section 31 to 301, which talks about maritime liens that arise by operation of law. There's a Maritime Lien Commission. The Secretary of Transportation is running everything because we are all on the highway of commerce. The water came inland, so to speak, and now it's here under the law of trust. Everyone who comes into the courtroom is a ward in Admiralty, a ward of the court. We're in quod, in rem and quod proceeding in Admiralty in a title dispute, and we have to come in as the title holder or have interest or claim in the subject matter of the complaint, or we are the vessel, and they have arrested the vessel. We're not in common law in the courts, we're in Admiralty, and they get jurisdiction by arresting the vessel. They, lawyers, district attorneys, law enforcement, don't use the proper process, and they need to trick, cajole, deceive, pressure us to do whatever they need to do and have us make a mistake to give them in personam jurisdiction over us when we take on the attributes of a general appearance to the subject matter of the pleadings against the defendant in quod, in rem and quod, and we start acting in any capacity on the merits of the charges or by taking on the persona of a defendant vessel in rem. There's lots more to this, but I think you get the gist about prisons for profit. In tying this all together, it would appear that there are many laggard souls. Some are incarcerated in prison and some are working in the prisons, and many more are indifferent to what is going on in our country as far as prisons and prisoners are concerned. When I explained my case to women, many said, "Why do you bother trying to change things, to stand up to the system?" I'd always explain to them the concept of our earth trying to ascend to higher consciousness and take all the souls along, even the laggard souls. I'd explain how we could use the light of the angels, masters and God through us as flashlights. The source for this bulletin is Ed Branham of Texas, and this message was appended to his email. I do not have a problem with giving out my email address. All the feds have known it for years. It's hard trying to teach those persons while they are monitoring me. And quote, the following messages for all corporate agents, informants, investigators et al. Working in collusion by monitoring my mail and any other communications without my permission, and quote, I sui juris, a Republic of Texas national American sovereign neutral non-combatant by law declare to all corporate combatant federal and or state agents and or third parties that I am not a corporation and or United States state-created fiction, and I am accepting all oaths and affirmations declared under penalties of perjury and quote, so help me God, and quote, am returning all actions from the same being brought sought against me for want of geographical jurisdiction and venue, and quote, I bless God my Creator and ask His blessings and protection for the land of Texas against all trespassers, and quote.